The International Criminal Court is now in session.
Good afternoon to the parties and to all observers today. We're here to have hearings, oral arguments in the case of Prosecutor versus Lord Blaze. My name is Marie O'Leary. I'm your presiding judge today, and I'm joined by my learned colleagues, Judge Asaala and Judge Botero. First, we'd like to have appearances of the parties, the prosecution and the defense, and then we'll go into the arguments. As you know, each of you will have 25 minutes per side, and with a small bit of time for rebuttal. So first for appearances, prosecution.
Thank you, Madam President. My name is Lynn Sophie Temp, and I will appear on behalf of the Office of the Prosecutor. I'll be speaking for the full 25 minutes.
Thank you. And appearances for the defense.
Good morning, Madam President. My name is Julia Ospina, and along with my co-counsel, Mr. Thomas Ferreira, we will be representing the Counsel of the Defense. I will speak for around 14 minutes, and my co-counsel will speak for the last 10.
Thank you both. Prosecution, you have the floor.
Thank you, Madam President. May it please the Court, the present matter is of considerable concern both to the Earthbower community and the broader international community. The alleged enslavement of at least 30,000 Earthbowers cannot go without international scrutiny, and specifically Lord Blaze must be tried for his conduct before this court so that his criminal responsibility can be judicially determined and his victims can obtain justice. Your Honour, we will be making the following 4 submissions. Firstly, the court has jurisdiction in the case against Lord Blaze. Secondly, the case is admissible. Thirdly, the prosecution would serve the interests of justice. And lastly, there are reasonable grounds to believe that Lord Blaze is criminally responsible for the alleged crimes. Turning first of all to the issue of jurisdiction, Your Honours, the resolution of this issue turns on whether jurisdiction ratione materia can be established on the facts. The onus rests on the prosecution to prove this on the balance of probabilities in accordance with this court's decision in the 2010 decision in the case of Bemba, paragraph 203. The prosecution submits that both the contextual and material elements of crimes against humanity of enslavement have been met. Therefore, our submission has 2 limbs. I turn now to the first limb, the contextual elements. We submit that the conduct has satisfied the contextual elements of crimes against humanity pursuant to Article 7.2 of the Rome Statute. We submit that the following 5 elements have been established. Firstly, there was an attack directed against the civilian population. Secondly, that attack occurred pursuant to state policy. Thirdly, the attack was widespread or systematic. Fourthly, there was a nexus between the attack and the individual acts. And fifthly, there was knowledge of the attack. First of all, then, we submit that the Earthbowers' civilian population were the primary target of the attack. Since the government cracked down in 2015,
Counsel, can I ask you to pause for 1 second? Because I'm getting some technical difficulty and I don't know if it's just me. Can I?
Me too. It is the counselor speaking as if it was in slow motion.
Okay,
Yeah.
thank you.
Yeah.
Counsel?
Apologies, Madam President. I believe my Zoom got disconnected.
Understandable.
Resume.
Yes, please. Thank you.
Thank you, Madam President. As I said, 40,000 Earthbowers were arrested simply for commemorating their fallen community members. And this suggests that the attack was in fact directed against civilians and not members of the armed forces or other legitimate combatants. Secondly, Article 7.2 of the Rome Statute furthermore requires that the attack be committed pursuant to or in furtherance of a state or organizational policy. As the detention centers were set up and overseen by the Ministry.
Council, can I ask you to stop for one moment, and can I again ask the other judges in the bench clerk if we're having difficulty?
Satisfied.
Yeah.
Thirdly, the pre-trial chamber in its Article
Council, can I ask you to pause for one moment?
We cannot hear her properly. You may need to do something.
Council, we have experienced the same issue. Is it possible to potentially, I don't know if it's to...
I'm terribly sorry about that. I'm moving to a different room as we speak. If you could give me 2 seconds.
Yep.
And you might want to take off the video. This may improve the quality of the sound.
Onto a different network in a different room.
Sometimes that helps. So you may proceed. Thank you.
Thank you, Madam President. As I've said, the pre-trial chamber in the Article 71 decision in the case of Bemba considered that widespread concerns the geographical area or the large number of victims. And Centuric alone allegedly housed about 100,000 prisoners, and there were 40 detention centers in total located throughout the Fire Republic. As such, the attack was evidently widespread, both in terms of its geographical reach and the large number of victims. Indeed, in Bemba, for example, the court found that 1,000 victims was sufficient to meet this threshold of widespread. On the fourth element, we submit that the acts were not isolated. The detention was related to the enslavement, and indeed the 2015 crackdown was a campaign against the Earth Boer people that culminated in this enslavement. Finally, on knowledge, we submit that the perpetrators had the requisite knowledge pursuant to the case of Sonovich, heard by the appeal chamber in 2014. We note that Lord Blazer's specific knowledge will be addressed in my final submission. For the purpose of the contextual elements, the intermediary's knowledge is sufficient for the purposes of jurisdiction. For these reasons, Your Honours, we submit that the contextual elements have been satisfied. I turn now to our second limb of the first submission, namely that the material elements of crimes against humanity are met. The key issue here is whether there has been an exercise of ownership rights over the Earth Boer people that were detained at Centuric and the other camps. The crime of enslavement was considered by the International Criminal Tribunal for Yugoslavia in the Kunarak case. The appeals chamber stated that whether an act is a form of enslavement will depend on the indicia identified by the trial chamber in that case. I therefore point to the following 4 factors as evidence of enslavement. Firstly, the detainees were subjected to forced labor. The Earth Boers' labor was effectively being loaned out to Joe Snowflake's automobile company, which is also supported by the available aerial footage that has been obtained, as well as Haru Rock's testimony. It's furthermore been reported that detainees at Central Reg and the other slave camps were first forced to work 12 hours a day, every day of the week. And this is contrary to the UN's 2015 resolution on the standard minimum rules for the treatment of prisoners. Specifically, rule number 102 states that prisoners should have at least 1 rest day. Secondly, there's further evidence to suggest that detainees were subjected to cruel treatment and abuse. For instance, if detainees were too weak or refused to work, they were forced to stand outside in the snow all day in front of a picture of Lord Blaze without any food or water. And thirdly, there were severe measures taken to prevent detainees from escaping. Indeed, Howard Rock was the only one who survived an escape attempt in January 2019, and aerial footage has also shown Tenerife to be a heavily guarded island fortress. Lastly, it has also been reported that earth-boers were prohibited from exercising their earth-boers rituals and speaking their own language, and had their passports confiscated on arrival and were not returned these when they were released, which again amounts to a form of psychological and physical control. For these reasons, it is submitted that the court has jurisdiction in the case against Lord Blaze, as both the contextual and constitutive elements of crimes of humanity, again, of enslavement, have been met. Turning then to the issue of admissibility, in response to the defense's unfounded challenge to the admissibility of this matter, we submit that the defense is not dispensed with the burden of proving that this matter is inadmissible. The prosecution will make two submissions under this heading. Firstly, that the amnesty procedure in this case is not trial for the purposes of the Rome Statute. And secondly, that the amnesty procedure did not deal with substantially the same conduct as this prosecution would. Jonas, the prosecution accepts that international law is still in the developmental stage on the question of acceptability of amnesties. The pre-trial chamber in the recent Gaddafi case noted a strong, growing universal tendency that grave and systematic human rights violations are not subject to amnesties under international law. Irrespective of the court's consideration of the legal status of amnesties in the abstract, this amnesty is not sufficient to be invoked in any event. Pursuant to this court's decision last year in the case of Gaddafi, paragraph 48, Lord Blaze must have been the subject of a completed trial which resulted in a final conviction or acquittal and which has acquired res judicata effect. However, the amnesty procedure in the present case lacks any of the features consistent with the term trial, unlike some more comprehensive amnesties. In Lord Blaze's case, the amnesty has only confirmed...
Counsel, can I stop you there quite quickly on this? Before we get into whether or not it was a trial, can I just ask you, as far as the finality of the amnesty, the fact that a judge has signed off on it, and it appears that there's no appeal procedure for this actual judicial action, would the prosecution consider that this is final, the amnesty granted at least was final, even if it doesn't constitute a trial?
Yes, Your Honour, the prosecution takes no objection with the fact that the amnesty itself is final. The issue, as we see it, is that it's not a procedure which has resulted in a conviction or acquittal in that sense. It's in that sense not a criminal trial, but something altogether different. But yes, we do accept that the amnesty in this case is not subject to appeal, it appears. As I was saying, in Lord Blaze's case, the amnesty has only confirmed that a public apology has been issued, and any judicial control was limited to confirming whether the preconditions set out in Article 3 of Law number 14 had been met. It therefore involved no interrogation of the evidence speaking to Lord Blaze's role in the atrocities, and it also appears that no voice was given to the opposing view. It therefore is not a trial in any meaningful sense of the word. Secondly, the amnesty does not cover the same conduct as this prosecution. Article 1 of Law number 14 clarifies that it applies to those who took part in the hostilities in Black Mound. Its scope therefore appears to be limited to the armed struggle between the BNS and AANG, rather than the enslavement of earth-boers at Centuric and the other detention centres. Secondly, as I've previously set out, any judicial control was limited to confirming that the preconditions for granting amnesties set out in Article 3 of Law number 14 had been met. In short, the amnesty only confirms that Lord Blaze has apologised for his lack of knowledge of the atrocities. In contrast, this prosecution would entail a thorough interrogation of the facts and a fair assessment of whether Lord Blaze bears any criminal responsibility for the alleged crimes. The amnesty does not therefore cover the same or substantially the same conduct as this prosecution, and so cannot be invoked to stay this prosecution. Turning then to my third submission, that the case against Lord Blaze would serve the interests of justice. The term interest of justice is not defined in the Rome Statute, but the court may find some guidance in the 2007 policy paper on the interest of justice issued by the Office of the Prosecutor. The interest of justice test is to be guided by the objectives of the Rome Statute, namely the prevention of serious crimes of concern to the international community through ending impunity. The test is therefore a narrow one we submit, and as the document says, it should not be conceived of so broadly as to embrace all issues related to peace and security. This notion has been reflected more recently in the appeal against the authorization of investigation into the situation of Afghanistan, paragraph 94, which effectively suggested that whether prosecution is in the interest of justice is not reviewable by a pre-trial chamber. In any event, the prosecution would like to make two submissions on the point of interest of justice. Firstly, the Fire Republic's self-avowed peace process is not a valid reason to cease prosecution. Lord Blaze argues that it would not be in the interests of justice to continue with this prosecution as it would destabilize the peace process. Jonas, we've heard evidence today concerning political repression, unlawful detainment, and enslavement, culminating in these crimes against humanity of enslavement. To take Lord Blaze at his word and allow his self-declared peace process to stop a prosecution from being brought would be contrary to the purposes of the Rome Statute. To stop the proceedings at this early stage on the basis of Lord Blaw's fears of destabilization would mean that crimes of serious concern could remain unpunished, and it would only embolden others to act with impunity. In any event, the situation in Black Mound has been stable since the peace agreement has been reached in the summer of 2019, so 2 years ago, and we submit that there's been no credible evidence given to support Lord Blaze's contention that this would indeed destabilize the peace process. Secondly, we submit that it is in the interest of justice to prosecute, given the gravity of the alleged crimes. We submit that this crime is very serious, and this weighs heavily in favor of pursuing this matter. As stated in the 2004 decision in the case of Morris Cullen, the gravity of the crime will be assessed quantitatively and qualitatively, take into account its scale and nature and the manner and impact of its commission. As I've previously touched upon, the imprisonment was clearly widespread. 30,000 earth-boers were imprisoned by, at least 30,000 earth-boers were imprisoned by the BNS at Centurick alone, and Centurick is described as one of the biggest detention centres, suggesting there were likely even more populated sites. Entire families were held there, and people were arrested only on the basis of commemorating the deaths of their countrymen. There was an indiscriminate approach as to whether actual combatants were detained. I've already touched upon the dire conditions at Centurick and the abhorrent forced labour that detainees were subjected to. For that reason, we would submit that in these circumstances, the gravity threshold is met, and it would be in the interest of justice to proceed.
Counsel, can I go back quickly to where we were talking about the peace process? And you indicated, and it's just a little bit before, you indicated that there was no evidence that this prosecution could disrupt the peace process. But the person who's challenging here is the president of the country. Wouldn't the defense and the president himself be the best place to know whether or not this would cause a disruption to the peace process?
Madam President, Lord Blaze clearly has a vested interest in arguing that this prosecution would destabilize the peace interest and would therefore not be in the interest of justice. And for that reason, I submit that on the basis of his pure assertion that would do so is not enough, given the fact that he would obviously have ulterior motives for saying so.
Just one quick follow-up question. Is it up to the chamber to decide interest of justice? Because you cited to the policy paper of the OTP and the Afghanistan decision, referring to the prosecution's assessment of interest of justice. Is it for this chamber to make that assessment, or are we to rely on the prosecution's position of whether it's in the interest of justice or not?
Your Honor, it is prosecution's submission that it is not following the Afghanistan case. It appears not to be up to the pre-trial chamber to decide on the interest of justice. And indeed, this is also what Article 53 suggests, that the interest of justice is a matter for the office of the prosecutor to decide.
Thank you.
Thank you, Your Honor. Turning then to my final submission on the issue of criminal responsibility, the prosecution submits that Lord Blaze is criminally responsible for crimes against humanity under Article 28B of the statute. The crux of this issue turns on whether there are reasonable grounds to believe that Lord Blaze had the requisite knowledge, control, and ability to take all necessary and reasonable steps to prevent or stop these crimes of enslavement. We submit that he did have criminal responsibility for these crimes for the following three reasons. Firstly, Lord Blaze had a superior subordinate relationship between Asaala and the BNS. Secondly, he had the requisite mens rea, so the requisite knowledge. And finally, he failed to take any steps to prevent or stop the commission of the crimes. Firstly, following the Bemba case, the interpretation of the term subordinate is broad and covers both de facto and de jure control of subordinates with regards to the ability to prevent or punish the commission of crimes. In general terms, as President Lord Blaze had the power to issue orders, and specifically the exhibits and case facts show that Lord Blaze had the power to issue orders to Asaala regarding the organization of the camps and to order the release of prisoners, as well as the power to stop the commission of any of these crimes, given that he ordered the BNS to bring an end to the conflict and to dissolve the camps in the summer of 2019. Lord Blaze is therefore clearly in a superior relationship with the relevant agents. Turning to the second limb, it is submitted that he had actual knowledge of the crimes. It is not in dispute, we submit, that Lord Blaze was aware of the scale of violence and repression in the summer of 2018 when Earthboers were killed, forbidden from practicing their religion, and arrested on the basis of commemorating the clashes. Reading exhibits 1 and 2 together, it was clear he was also aware of the very dire conditions in the camps and that the detainees were not as much learning trade skills as suggested by Asaala, but being made to work on an industrial scale. Given also the fact that Harry Rock, one of the leaders of AANG, gave his account of prison.
1 second. Are you prosecuting him for the killings?
No, Your Honor. We simply.
So what the knowledge of the killings has to do with the result?
Sorry, I'm trying to build up to that. We are saying, given the fact that he was aware of the unstable situation in Black Mound prior to 2018, he ought to have been put on notice or in making further inquiries into the camps rather than just taking Asaala's word for them being education centers. This was clearly a very serious situation in earlier 2018 as well. We therefore find it not credible that he is suggesting that he had no idea of what was happening in the detention centers, or alternatively, that he was willfully turning a blind eye to what was happening there.
So from the killings, you presume the knowledge?
No, this was merely background to our submission. We're just saying that these killings had happened. We're not necessarily inferring from the fact of the killings he had knowledge. We're saying that this was a serious situation, which, regardless of his actual knowledge, he should have been monitoring the situation afterwards in greater detail than he clearly had or pretends or submits he has. Thank you. Therefore, given also the fact that Harry Rock, the leader, one of the leaders of AANG, gave his account of the prison conditions in an interview to an international NGO, we find it very hard to believe that Lord Blaze was not made aware of this as well. Given the national security threat that the black man represented, we invite the court to find that Lord Blaze acted with willful ignorance by decreeing they would only receive updates from the BNS once every 6 months. And it also appears that Asaala in any event was updating Lord Blaze continuously anyways. Lord Blaze, therefore, at the very least,
Sorry, where did you find that in the facts of the case? That he was being updated regularly?
He was updated every is that he was to be updated every 6 months is paragraph 7b, and we were referring to the telephone conversation at Exhibit 1 that he was clearly also being updated by Asaala outside of that, it appears.
Thank you.
Thank you. We therefore submit that at the very least, Lord Blaze consciously disregarded information which clearly indicated that his subordinates were committing crimes against humanity of enslavement, and at most he was clearly aware of the nature and scale of what was happening. Turning to the third limb, whether Lord Blaze, with his knowledge and ability, failed to take all necessary and reasonable steps to prevent these crimes. As these detention centers were administered by the BNS and the president provided raw materials to set centers, it should follow that these crimes concerned activities under the effective control of Lord Blaze. Initially, Lord Blaze failed to take any necessary reasonable measures to put a stop to the crimes, even where, as we have mentioned, he was in a position to know, or at the very least, have reason to investigate what was going on. Only when the violence risked spreading beyond the black man's borders did Lord Blaze put an end to the conflict, yet he did not submit the matters for investigation to the competent authorities. To summarize, he had a superior and subordinate relationship with agents that were under his effective control. Those agents committed crimes against humanity that were within the responsibility of Lord Blaze and occurred as a result of his failure to exercise proper control. And Lord Blaze had or ought to have had knowledge of these crimes. There are therefore reasonable grounds to believe that Lord Blaze is criminally responsible under Article 28b of the statute. Madam President, Your Honours, the bench will soon hear submissions from our learned friends who will undoubtedly seek to challenge the evidence presented. We say to the court that ultimately the question here is not whether or not Lord Blaze committed crimes against humanity beyond reasonable doubt, but whether pursuant to Article 58(1) there are reasonable grounds to believe that he did. Unless there may be a further assistance to the court, that concludes my submissions.
Were there any questions from my fellow judges?
No further.
Thank you. In that case, then, thank you very much. Arguments from the defense?
Good morning, Madam President, Your Honors. May I please the court? We are standing here today, Your Honors, on behalf of Mr. Blaze, a man who has made his due diligence in order to maintain national and public security within a difficult context of an armed conflict. And still, he's being painted by the prosecution as a ruthless criminal. The Council of Defense will prove, firstly, that this court does not have subject matter jurisdiction, and secondly, that the case ahead is inadmissible. Subsequently, my co-counsel will additionally prove that the present case does not serve the interest of justice, and lastly, that Mr. Blaze is not criminally responsible for the charges made against him. Your Honors, the case against Mr. Blaze does not fall within the subject matter jurisdiction of this court, pursuant to Article 5 of the Rome Statute. Firstly, assessing the contextual elements, the defense submits that they are not established, and we split into our submissions. On our first submission, the attack cannot be conceived as either widespread or systematic, as there has not been any attack at all, part of which the alleged act of enslavement would have been committed. Your Honors, since the Akayazu trial chamber decision, case law has systematically defined an attack as multiple acts that constitute much more than a mere aggregate of random or isolated acts. Instead, there is a requirement of a certain pattern, and the existence of a degree of planning or organization is the necessary nexus among otherwise unrelated acts, rendering them as an attack. According to the prosecution, the alleged enslavement charges would have been part of a broader attack, consisting of violent acts committed against the Earthbower population since summer 2018. However, Your Honors, these acts, which underlie the context of the detentions, cannot be conceived as an attack, as all the events were connected to each other solely on the basis of the nexus to the armed conflict, a legal category that is essentially different from the attack element for a crime against humanity. The nexus to the armed conflict, Your Honors, was defined in the Cunarache Appeals Judgment in paragraph 58 as being a legal category that relates acts that take place in the context of and are associated with an armed conflict. Therefore, it does not require any other element of organization, planning, or common policy as the attack element for crime against humanity. In the concrete case, the relation between the events listed by the prosecution lies on the fact that the acts of violence took place in furtherance of and under the guise of an armed conflict, as demonstrated by paragraph 6 and 16. Your Honors, there is no other element, there's no element at all that would indicate that a policy common to those events would amount to an attack. The anti-extremist executive order, the main element which would be relied upon by the prosecution, is not sufficient to establish the attack element, as this element, Your Honors, would require that the organization and planning be present during all of the acts submitted by the prosecution as part of the attack. This means that the common policy would need to be present since the summer 2018 violent clashes. And Your Honors, the anti-extremist order was signed only on latest September 2018, according to paragraph 7, months after the first conflicts emerged, in which the prosecution submits as part of being the course of conduct amounting to an attack. Therefore, there has not been any attack because the organization and planning requirements have not been established during all these events, which relate to each other solely on the basis of the nexus to the armed conflict. Therefore, the elements of widespread and systematic is nullified because an attack has not been settled.
Counsel, can I quickly interrupt? You've cited
Yes, Your Honor.
a couple of cases from the ad hoc tribunals from the ICTY and the ICTR. Do we have any jurisprudence from the ICC that you can cite to about what would be required to fulfill these chapeau nexus elements?
The nexus to the armed conflict, Your Honor?
Correct.
Normally, these assessment, as is related to war crimes, we have much more jurisprudence in ad hoc tribunals. However, even though such decisions are not binding for the present court, they are important to enlighten this court in decisions that are not mainly present in this court's jurisprudence. Also because it is important to maintain the need to ensure consistency compels the international courts to pay close attention, not only to its own decisions, but also to other criminal courts' decisions. This is why we submit that ICTY and ICTR's rulings would be relevant to this court. If I may proceed.
I just want to check, you're asking us to rely on the ad hoc jurisprudence for this point, correct?
Yes, in this matter, yes. However, in this matter, we are just stating that nexus to the armed conflict would be a different legal category. And this would be the category that the prosecution might be using to define the nexus between the events. However, we submit by the concrete facts of the case that the nexus that would amount to the chapeau required by the attack element, which is provided in the Rome Statute, and the elements of the crime is not established as required by such law, such provisions. Moving on. Thank you, Your Honor. Moving on to the next issue, on our second submission, we say that if there was an attack, it was not directed against a civilian population. Your Honors, it is well established by this court that as the term civilian is not defined in the statute, there is the need to resort to the principles of international humanitarian law to define it, by which, according to the Bemba and the Katanga case in paragraph 78 and 1102, the civilian population comprises all persons who are civilians as opposed to combatants. It is important to emphasize that although the legal status of a combatant does not exist in situations of non-international armed conflict, which is indeed the situation ahead, this legal absence cannot lead to the deduction that all actors involved in the conflict are civilians in the same manner. Indeed, it is considered that different legal regimes apply to civilians and to members of armed groups, either during conduct of hostilities or when they fall into the hands of the enemy. By such rules, if in one hand, the states have the legal authority to conduct attacks on members of armed groups in a different manner than civilians, on the other hand, when they fall into the hands of the enemy, those members may be interned without the individual specific guarantees that are afforded to civilians. In short, Your Honors, members of an armed group are not considered civilians. And having that been established, the defense asserts that in the concrete case, the attack was directed to gang leaders and loyalists, members of an armed group with continuous combat function that are not considered civilians, and it was not directed against the civilian population. This is demonstrated not only by paragraph 8, in which it was stated that the 40 education centers, including Centuric, were aimed to detain terrorists arrested by the BNS agents, but also by Exhibit 1 that indicates that terrorists were the ones being sent to Centuric. The attack was not therefore directed against the civilian population, Your Honors, as required by Article 7. Moving on to the specific elements, the forced labor presented by the prosecution as an indication of the power attached to the right of ownership is not present, which leads to the deduction that the crime of enslavement has not come to pass. Your Honors, as noted in the Kunarach trial judgment in paragraph 542, international law makes clear that not all compulsory labor in armed conflicts are prohibited. This positioning is ensured in human rights instruments and in the Forced Labor Convention. In its Article 1, paragraph 2, certain forms of compulsory work or services which would otherwise have fallen under the general definition of forced labor are explicitly excluded from its scope. One of those situations perceived in a line D is work or service exacted in the event of war or other calamity situations. It is important to bear in mind, Your Honors, that according to the Forced Labor General Survey, this exception can only be invoked for work that is strictly required to counter the emergency situation. In the concrete case, the fragile indicatives of work during the armed conflict in Centuric illustrates that if it happened, it was developed to maintain Fire Republic's metal-based work economy, as presented in paragraph 1. In fact, not only Ursatsila's interview in paragraph 9 demonstrates that detainees were taught mechanics, but Exhibit 1 in correlation with 2 demonstrates that if the detainees were working, they were using steel, rubber, glass, and engine supplies, all necessary for a metalwork-based industry. Your Honors, work which aims to maintain the state's economy is indeed a necessary measure to counter an emergency situation consisting of an armed conflict. The risk posed by such scenarios have consequences much graver in the access of food, medicine, employment opportunities, and internal and external investments. This is why the defense submits that the alleged compulsory and lawful work by the detainees cannot be conceived as forced labor in order to establish the crime of enslavement. Moving on to the next issue on admissibility, the defense posits that the present case be deemed inadmissible, pursuant to Article 17, 1C, and 20, paragraph 3. The principle of ne bis in idem, perceived in such provisions, applies where the relevant person has been tried by another court. According to Article 31, paragraph 1 of the Vienna Convention on the Law of Treaties, the language of the statute must be construed by reference to the ordinary meaning of the terms used in their context and in light of the objects of the statute. According to the Oxford Legal Dictionary definition, Your Honors, the ordinary meaning of a trial is an action taken in a court to settle a dispute. This means that the ne bis in idem principle has a mainly judicial requisite, and that in order to render a case inadmissible, it must have been subject to a previous court proceeding. In the concrete case, this requirement is present, as the amnesty was not granted lacking effective judicial control. Indeed, it was before a judicial and not an administrative body that the conditions established by the law number 14 were considered to be present, according to paragraph 23. Furthermore, on a second scope, according to the Bemba case, paragraphs 248, the Nebizin principle also relates to the existence of a previous final judgment in the sense of having res judicata effect. Res judicata, Your Honors, as a general principle of law, has two main limbs. If in one hand, according to the Gaddafi appeals judgment in paragraph 56, a decision is considered final and with res judicata when it's no longer subject to any appeal. On the other hand, according to the genocide case, N92, judged by the International Court of Justice in paragraphs 126 and 59, aside from the appeal evaluation, a decision has res judicata when it has been definitely settled and expressly determined. In the concrete case, the res judicata principle is also present, not only because the judge's ruling on the granting of the amnesty was final, as asserted by the prosecutor itself, not subject to any appeal, according to clarification 6, but also because it was entered in formal and substantive terms by a competent court, having been therefore definitely settled and expressly determined as required by case law. This is why the defense submits that the present case must be deemed inadmissible. Yes, Your Honor.
Yes, I have a question on this in asking for your response to the prosecution. Both Article 17(1)(c) that you've actually referred to in bringing this argument, and the principle of ne bis in idem under Article 20 refer to a person being tried, indicating that there should be a trial. And the prosecution has said that there has been no opportunity for the other side to be present in this proceeding, even though judicial was a proceeding that was an amnesty proceeding. How can you define for us that the amnesty that occurred in this case suffices for the term trial that's required in the statute?
Thank you for your question, Your Honor. Indeed, what the defense submits is that there is room for this court to consider that restorative justice methods, such as amnesties proceedings, which amount and which suffices the two requirements mentioned by the defense, the judicial and res judicata, they may amount to a trial. Firstly, because the language of Article 7 and Article 21 is sufficient malleable to include restorative justice methods in such definition, but also reaching specifically to the travaux préparatoires. Because when referring to the proposal of allowing the court to try a person who had undergone proceedings based on amnesties, some delegations made clear that the statute should not permit the court to intercede in political decision-making process of a state, which would include pardons and amnesties. And ultimately, because of such a position, the proposal was abandoned, which would lead the defense to conclude that states that participated in the Rome Conference acknowledged that the principle of ne bis in idem would apply to amnesty proceedings and related restorative justice methods. In other words, a person who has received an amnesty before the judicial body would have been tried by another court. And furthermore, regarding the Gaddafi appeals judgment mentioned by the prosecution, the Gaddafi appeals judgment backtracked from the PTC holding, stating that amnesty would be incompatible with international law. This will leave this court a certain room to establish that amnesties and other restorative justice could amount to a trial and not only retributive justice methods, as has been assessed in South Africa, as has been assessed in Guatemala, in El Salvador, in many countries which have received amnesties and have gone through periods of transitional justice. If I'm not of any... Yes, Your Honor.
Madam President, if I may, Counsel, are you familiar with the situation of Colombia and the justice and peace law and the special jurisdiction of peace and the negotiations with the office of the prosecutor and the decision not to prosecute the case and the requirements that were considered relevant in order to deem these peace processes sufficient to establish the threshold?
Yes, Your Honor. I'm sorry, could you rephrase your question? It was concerning about the justice process in Colombia. Yes, just confirm.
Is there any evidence of a trial? The fact that an amnesty occurs, does it in itself amount to a trial in the context of the Colombian?
Yes, Your Honor, we submit that in that context, there could have been a trial for the purposes of this court consideration. So if if this court would initiate an investigation in the situation of Colombia, this has to be taken into consideration. The trial, meaning in the Article 17, could encompass restorative justice methods to include such situations in the meaning of trial, and therefore bar the prosecution in this court and establish this only in the national system jurisdiction.
Is it restorative justice based on the utmost respect and participation of the victims in the process?
Yes, normally restorative justice process.
Did this happen in this case? Have you any evidence that this happened in this case?
Yes, there has not only been an amnesty, but also a truth commission, and the amnesty was indeed elaborated with the consent of all the parties involving the parties in the conflict. This is established by paragraph 17, and also in the clarification 5, which states that both parties to the conflict were participating this restorative justice process. If I'm not of any further assistance, my co-counsel will proceed with the last two submissions. Thank you.
Thank you. Good afternoon, Mr. President, Your Honors. May I please the court, and I will address the last two submissions. Firstly, about the interest of justice. Your Honors, the interest of justice can only be considered where positive determinations have been made on both jurisdiction and admissibility, as provided by the OTP policy paper on the interest of justice used by this prosecution. And if this is the case, the court can review the interest of justice, as contrary to what the prosecution stated, as held by the pretrial chamber of this court in the situations of Burundi and Georgia, respectively in paragraphs 190 and 58. Accordingly, we submit that this case does not serve the interest of justice, firstly, because this case is not likely to proceed, and secondly, because it would destabilize the peace process in FAR Republic. Your Honors, according with the pretrial chamber in the Afghanistan situation, an investigation would only be in the interest of justice if prospectively it appears suitable to result in effective investigation and subsequent prosecution of cases within a reasonable time frame, as provided in paragraph 89. Because unfortunately, this court is not equipped to address all scenarios where the most serious international crimes might have been committed. However, in the present case, it is unlikely that pursuing prosecution against Lord Blaze will result in effective prosecution, specifically due to the lack of reasonable grounds to proceed with it. For instance, the prosecution relies mainly on one single witness to issue a case with alleged 30,000 victims, which is absolutely insufficient to provide that. Moreover, Your Honors, neglecting the national proceedings undertaken and prosecuting Lord Blaze would destabilize the peace and justice process in FAR Republic, as it would prolong violence and lead to further possible human rights violations. Your Honors, to establish peace, both parties of the conflict agreed that the justice process would focus on restorative methods, such as true commissions and amnesty laws, as explained by my co-counsel, and by ensuring that the truth is established and victims receive public apology as provided in the case facts, paragraph 17 and 20, FAR Republic enacts a very important peace and justice process, which cannot be neglected. Yes.
Just seeking your clarification, is it your submission to this court that we should embrace impunity insofar as what Lord Blaze has done, as we give a chance to the peace processes that are ongoing? Is that your submission to this court?
Thank you for your question. No, this is not our submission, because as my co-counsel explained, different situations, different countries demands different forms of justice. We are not asking for impunity. We are asking to respect the justice process FAR Republic choose to follow in their home situation. And this concludes my submission on the interest of justice. Your Honors, moving to my second submission about superior responsibility. This is a mode of liability, and it's important that all the legal requirements of this mode of liability are fulfilled. Otherwise, this would violate the nullum crimis in lege principle as provided by the pretrial chamber of this court in the Bemba case, paragraph 423. I shall challenge, due to the lack of time, mainly the knowledge element, but I shall call your attention that this mode of liability has a requirement not addressed by the prosecution, namely the nexus between the omission of the commander and the commission of the crime. And I would like to emphasize that the absence of any legal requirement of this mode of liability would exclude superior responsibility. But concerning knowledge, Your Honors, the civilian commander should either know or consciously disregard clear information about the crime itself, as provided by the Article 28b of the Rome Statute. And I would like to call your attention for the question of Judge Juan to the prosecution when he asked about if the evidence could provide that the Lord Blaze knew about other conditions. I would like to emphasize that the knowledge requirement demands that the commander actually knew about the crime itself and not about any other conditions. And the prosecution failed to show that, as I'm going to show. The knowledge of the commander, Your Honors, cannot be presumed, and what needs to be inferred is the accuser's knowledge and not of the general public, as provided also by the pretrial chamber in the Bemba case, paragraph 191. And it's important to keep in mind that even at the pretrial stage, it is necessary to fulfill the required standard of proof of reasonable grounds to believe that requires the prosecution to be satisfied that the available information shows a rational, factual basis to reach its conclusions. And this means, Your Honors, the Lord Blaze's knowledge should not be implied by public information, such as Harry Rock's interview, the aerial footage, or Joe's snowflake ladder, since there is no evidence that the president had access to it. And according with clarification number 4, those information were only published months after the referral to this case to the court. Your Honors, the only clear information about the alleged crime the Lord Blaze could have access to were the reports from Asaala. However, there is no evidence about their content. Accordance with the Articles 66 and 67, we cannot presume against the defendant that the crimes were described on those reports. In addition,
Counsel, can I stop you right there and just ask, saying
Yes.
he doesn't know about it, he doesn't have any information. He did give an order that his minister should take care of this. Does he not have some obligation to follow up? Wouldn't he fall under a conscious disregard standard for not actually finding out what's going on at these camps?
Thank you for your question, Madam President. This is important to address because the consciously disregard threshold only would be achieved if clear information was previously provided for the commander to ignore it. And if I may ask 1 more minute to conclude my submission.
For a conclusion, yes.
Thank you. In addition, Your Honors, paragraph 8, Asaala described the center rig as an educational center, and by this pattern, she would use this description in the reports and not admitting any potential crime. That's why there are no reasonable grounds to believe the Lord Blaze knew or consciously disregard information about the alleged crimes. To conclude, Your Honors, the defense would like to request this court to accept all submissions made. Thank you for your attention, and may I please the court.
May I ask, Your Honor, may I ask him, is it reasonable to assume that 30,000 people are terrorists? That large scale of, in the context of the history of humanity, is it reasonable to assume that all 30,000 people, members of the population, so many, are just terrorists?
Your Honors, according with the exhibits number 1, when they were holding to the detention centers, actually Asaala described them as terrorists, and this is an indication that this big number of detainees would be members of armed groups.
Shouldn't Lord Blaze question whether those so many terrorists, 30,000, is it reasonable?
Thank you for your question again, Your Honor. As I previously stated, the superior responsibility demands clear information about the crime itself for the commander have the obligation to take measures. And this does not in any way provide clear information about the crime for him to have the obligation to follow through.
Thank you.
Thank you.
Thank you, defense. Back to the prosecution. Do you have any rebuttal?
Yes, Madam President. Thank you. I'll be making 3 short submissions. Firstly, in reference to the point that the defense said in terms of the requirement for a policy and a nexus and what constitutes an attack. The pre-trial chamber in Nataganga set out that it is the commission of the acts referred to in Article 7.1 that constitutes the attack, and besides the commission of these acts, no additional requirement for the existence of an attack should be proven. So it's the actual enslavement that constitutes the attack, and any other acts which fall outside of that are merely additional supportive evidence of such an attack. And secondly, with regards to the policy element, the pre-trial chamber in Bemba also discussed that element and suggested that the policy does not have to be formalized as such. The attack merely needs to follow a regular pattern. So it's merely required that attack is planned, directed, or organized, as opposed to spontaneous or isolated acts of violence. And this is clearly the case here, as these detention centers were set up and followed by the Ministry of Interior and were clearly organized. Secondly, as Judge Botero quite rightly pointed out, it is entirely not reasonable to assume that out of 30,000 detainees, at least, some numbers suggest much higher numbers of detainees, not all of these can have been terrorists. It is clear from the case facts that earthboers were simply labeled terrorists without any due process or investigation into their alleged wrongdoing. And earthboers' priests were repeatedly arrested and detained, and as I've previously said, entire families were detained. So the defense's submission that the detainees were simply terrorists or combatants or ANG leaders is clearly absurd or unfounded. Lastly, on the issue of amnesty, the prosecution, to clarify, does not say that amnesties can never amount to a trial. It's entirely possible to have more comprehensive amnesties which entail an investigation of the evidence or follow a proper trial, but this is not the case here. And defense counsel has also mentioned the Truth Commission, which was created to ensure the establishment of the truth, and suggested that this was an alternative. This commission was tasked with publishing a report before the end of 2020, and so far, to the prosecution's knowledge, no findings have been produced, or anything for that matter. And this clearly shows that there's no alternative mechanism of providing justice to victims. And in the absence of such, the trial, this prosecution should be admissible and progress to the next stage. Thank you, Madam President.
Thank you for that, prosecution. Defense, is there any rejoinder?
Yes, Your Honor, thank you. Relating the first submission made by the prosecution about the requirement of our policy nexus and attack, the defense admits that the case law that defines an attack is very sufficient in this court's jurisprudence. Because since the Akayazu trial chamber decision to the situation of Kenya pre-trial chambers holding, there has been many decisions that classify an attack and define an attack as being much more than a mere aggregate acts of isolated acts And there is the requirement of a pattern that would amount to an organization and planning. And this has been decided in the Bemba confirmation decision in paragraph 81, also in the Gababago case, in the decision and confirmation of charges in paragraph 66 and 67. So therefore, the definition of an attack is sufficiently clear to include this organization and planning requirement for it to be considered as an attack. And therefore, moving on to the second submission about the policy element, the defense submits mainly that although maybe aside from the fact that the policy, the anti-extremism executive order could not even be considered to constitute a policy because it was not directed to committing attacks against Earthbowers, because it does not even mention the words Earthbowers. In fact, it was directed to contain national security and public order in very vague terms. However, even if we consider this as a policy, the submission of the defense is that this policy could not be enough to establish the attack element, because this policy would have been signed on latest September, and the prosecution submits that the attack was happening since summer of 2018. So in this manner, the organization and planning must have been present since that time, and the anti-extremism was signed only months after. So this is why we submit that the organization, planning, and common policy to those events are not established to require and to amount to an attack with related acts. On a third scope, regarding the unreasonableness of assuming that at least 30,000 would be only members of armed group. Again, this is not exactly the submission of the defense. The submission of the defense, when stating that the attack was directed to Ang leaders and loyalists and therefore not to a civilian population, is that according to the prosecutor versus Bemba in the paragraph 91 and 92, an attack must be directed to a civilian population. And this means that the civilian population must be the primary object of the attack and not just an incidental victim of it. So in this manner, we submit that if, in the concrete case, we do not have information establishing the status of the detainees, if there was only members of armed groups or also civilians. However, even if we consider that civilians were inside Centuric, the attack was not directed to them, because the analysis that this court should focus is on ascertain whether any casualties that suffered by the civilians resulted from their having been intentionally targeted rather than having been only victims of unforeseen and unavoidable incidents. And this is indeed the case, because the attack, as presented before, was directed to Ang leaders and loyalists, according to paragraph 8, according to Exhibit 1, and according to paragraph 9 in Ursatsila's interview. This is why we submit that in the concrete case, the attack was not directed to civilians. Lastly, about the submission on the amnesties and the submission that the prosecution understands that amnesties can never, may in some situations amount to a trial, but this would not have been the case because the truth commissions had no produced any findings. I would like to bear in mind the clarification 5, which sustains that the Truth and Reconciliation Commission, which was comprised by both parties to the conflict, had a report, and the commission found that the parties committed crimes during the conflict. Both parties, not only one party or another, both parties committed crimes. And this is indeed a very common situation in conflicts, reason why a peace agreement is necessary as fast as possible to conclude any atrocities or mass violation of human and humanitarian rights by both parties to the conflict. If there are not of any further assistance, I thank you for your attention, and may I please the court.
Thank you very much. I want to thank both parties for their submissions today, and I didn't get a chance earlier to say, but thank you for indulging our slight delay at the start of this for the technical difficulties. At this point, the judges will adjourn and we'll have a small deliberation here to come back with some decisions for you. And we appreciate your patience now in the meantime too while we go to the deliberation room. Thank you.
I will now send the judges into the deliberation room and put the team members into separate breakout sessions.
Okay, I think we have everyone back. So I just want to say thanks for the patience, first of all, and congratulations to all of you to have come this far and worked this hard and put on some very wonderful arguments today that made it a bit difficult for us, of course, to have to try to weigh up all of the different parts of it and really come down to a decision that was very, very close. It is a difficult task at this stage to really try to find which team slightly maybe edged out over the other team because you were both so wonderful in your performances today and in your arguments and in the presentation of them. So it is the bench's pleasure, but also torture to try to announce the winning team here. And for this round, the winning team was the prosecution, N91. And we want to congratulate you, but also encourage everyone speaking here. As we said, all of you put forward really great arguments. There were some really creative arguments, and it's very important on both sides, and in particular, sometimes on the defense side, you have to be quite creative in how you're actually looking at the angle of it. So there was really, the arguments that you put on, some of them were the first time we've heard some of these arguments put forward in any of the rounds today or thought about these concepts. So we thank you for that. We want to say also, you know, as far as the technology goes, you had to wait us out, which only creates some stress. And there was a little bit of technology issue in there too. So great to every one of you for hanging into it and holding composure and keep that into the future rounds and in life generally as we live in technology land. All of you maintained a fantastic pace. Make sure that you're always keeping it to the clear arguments that you've delivered because they did come through in a way that we could understand, speaking slowly enough. One thing we just wanted to say on citations, make sure that you're using pinpoint citations where you can to be as clear as possible. And whenever you're looking to a citation, always just make sure that you're checking up on, you know, if there's any case that's maybe come after it, or in particular, you know, always read the paragraph before and after and get the context in full to make sure that it's not something that the other side can then come back or forth on too easily. And for the questions too, I just want to say everyone answered the questions in a very nice manner because you had a little bit of a hot bench today. But make sure to also then manage the time across the board, because I don't know in the next rounds or in life generally, next years, next, you know, lives, how hot your benches will be. So make sure to really keep on top of that, because sometimes the questions just keep coming. And so thank you for the answers to them as well. We really appreciated the attention to it. That's really all I have to say, unless my judges want to add anything further. Judges Asaala or Botero?
Perhaps you did not announce the speaker's decision. And now that I'm speaking, I would like to re-emphasize how impressed we were with both of you. This was like a photo finish decision based on an unanimous decision based on extremely well presented cases, wonderfully answered questions. We were delighted by your performances, both of you.
I think I equally echo my colleagues in congratulating the two teams. You have done extremely very well, both of you. Just that, you know, we had to find a winner. Yeah, and not to say that the defense is poorer, but we are all winners and we still have a room to improve on ourselves. So congratulations to both of you. Thank you.
And I've tried to check in here with my bench clerk. I don't know that we have the privilege of announcing the speakers at this time, but we have selected best speakers, and thank you very much for that. I guess that will be revealed, all will be revealed in due course. So at this point, I guess we're just going to say from the bench, good luck, and not just for the future rounds for those advancing, but for future years, future cases, for everything, and again, and careers, because you're all fantastic, and we're looking forward to you know, working more closely with you in the future. So thanks so much. and I hope you have a lovely afternoon.
Thank you.
Thank you
Thank
so
you.
much.